Good afternoon, Your Honors. The matter before the court is the case entitled Ginny Rafuse versus James Rafuse, case number 25 AP 025. Representing the appellant, James Rafuse, is Deborah Bucknam. Representing the appellee, Jenny Rafuse, is George Gay.
Thank you very much, and good afternoon again. We'll hear from counsel for the appellant first, of course. Please introduce yourself, identify your client, and then proceed.
Thank you, Your Honor. Good afternoon. My name is Deborah Bucknam, and I represent James Rafuse, the appellant in this case.
Thank you.
Yes, may it please the court. This case involves the statutory definition of abuse of children under 33 VSA section 4912. As the Eddy court that we refer to in our brief found the abuse of children under section 492 is actually a higher standard than spousal abuse, because the court found, and I quote, "A court must employ some level of deference when evaluating child rearing preferences." In this case, the court found there was emotional maltreatment, and that was the basis of the court's determination of abuse. Section 4912 defines abuse, emotional maltreatment, as a pattern of malicious behavior that results in impaired psychological growth and development. In this case, these children recorded their father, who engaged in some loud, angry yelling while disciplining his children. That yelling occurred 5 times in a total of 3 weeks, totaling 4 minutes, less than the amount of time this court has allowed me to argue this case. So we believe that there is no pattern here. Second, the definition of malicious behavior does not apply to this case either. Any court found that the physical contact between Mr. Eddy and his children, as well as his anger at them, did not constitute a malicious behavior, because they found it to be corrective. And in another case, not cited by us in our brief, Centano versus Satano, that's 219 Vermont 279, they specifically define malicious as motivated by a desire to harm the children. And there is no finding in this case of a motivation of harm to the children. So we believe that the definition of a malicious must include a motive on the part of the alleged abuser in order to find the behavior to be malicious. And there was no evidence of that in this case. This was a case involving my client correcting his children when they were not cleaning the house properly, and when they were back talking to him. Third, the definition says that it must impair psychological growth and development. The court did conclude that the children suffered emotional distress in this case, primarily because they recorded their father. That assumption that recording of their father was as a result of their emotional abuse is no evidence to support that assumption. But more importantly, the court did not specifically find any impaired psychological growth or development. Less than 4 minutes of emotional distress over a period of 3 weeks cannot be translated to impaired psychological growth and development. And finally, the court found there was a risk of further harm because father had voluntarily complied with mother's restrictions on parent-child contact.
You have 1 minute, counsel. 1 minute.
Thank you, Your Honor. I'll just quickly finish. Section 4912 defines risk as harm, and it's a very high standard. It says a significant danger that a child will suffer serious harm, which harm will likely cause physical injury or sexual abuse. None of that occurred in this particular case, so there could not have been a finding of risk of harm. Thank you, Your Honor.
Thank you very much. Excuse me. We'll hear from counsel for the appellee now. Please introduce yourself, identify your client, and then proceed.
Good afternoon, Your Honors. My name is George Gay, and I'm here this afternoon representing the appellee, Ms. Jenny Rafuse.
Thank you.
The standard of review in this case is one of deference. The court only reverses or overrules the family division in a relief of abuse order matters where there is an abuse of discretion, and there has been no such abuse of discretion in this case. The hearing in this matter occurred over 2 days. It was extensive testimony, extensive opportunity for the court to judge credibility of witnesses, weigh evidence presented. It wasn't a relief from abuse matter where the parties participated remotely. They participated in person with the court. That's important when considering the level of deference provided. There are 5 recordings that are the pivotal evidence in this matter as represented by Attorney Buckman. Recordings were taken by the children in the home, a marital home in which the father resided over the course of several weeks, Your Honor. The court looked at those recordings and in its decision noted specifically the transcript of those recordings. The court says, the transcript is disturbing, to be sure. However, it is the volume and tone of voice which are convincing. It's very important that the trial court, the family division, heard those recordings and considered the volume and tone of voice in those recordings, which happened over an extended period of time. At issue before the court was whether the children had been abused or neglected by their father. Abuse means, under the statute quoted by Attorney Buckman, a child whose physical health, psychological growth and development, or welfare is harmed or is at substantial risk of harm by the acts or omissions of the parent. In this case, the family division judge found that abuse occurred because the father's actions put the children's psychological and health and growth at substantial risk of harm. Also considered whether there was a risk of future harm as required under the relief from abuse provisions. And the court concluded there was. And the court specifically explained why it concluded that. And the facts support the court's, the findings of fact are accurate and the conclusions are supported by the facts. Specifically, these recordings occurred over a course of time right up until my client filed for divorce. And then once the interim domestic order was in place and once the divorce had been filed, the father's behavior improved. No more abusive language such as was heard in the recordings. And the court determined that it was the court's orders which held the father in check effectively and determined that it needed to issue a order in order to prevent future abuse.
You have 1 minute, counsel, 1 minute.
Or else without that order, there would be a risk of future abuse, specifically emotional maltreatment, which constitutes harm under the statute. The Eddy case, the real focus of that case was whether or not the narrow definition of abuse, which applies to children, would be employed by the court in that case, or whether the broader definition of abuse of a family member would be employed. court determined that the narrow definition should be employed. Then the court looked at whether abuse of the child had occurred. The family division in that case found no abuse. And in the Eddy decision, the court looked at whether there was physical harm. There was no one ever raised the issue of emotional maltreatment. It was all physical harm, and the court determined that there was only one instance, and it did not constitute physical harm as defined by the statute.
All right. Thank you very much. Your time has expired. How much time does the appellant have, please?
Appellant has 29 seconds remaining.
Counsel?
Thank you, Your Honor. I just want to make one correction in what Mr. Gay said. The court did not find that the behavior improved because of any court order. There was no court order for a long period of time, for several months, and the court found that my client voluntarily complied with the instructions of his wife regarding parent-child contact when he in fact would be able to see them at any time. So it wasn't a court order at all.
All right. Okay, and your time has now expired. Thank you very much. Please call the conclusion of the hearing.
The next